Hello, everybody, and welcome. Today's live stream is on the topic of disability discrimination. The information below came from the Employment Law Center of Maryland website in the article Disability Discrimination. Disability discrimination is unequal treatment that occurs when an employer treats a qualified individual with a disability differently because of their disability. This includes treating an employee less favorably because the employer assumes that the individual has a physical or mental disability. The federal employment law that prohibits disability discrimination is the Americans with Disabilities Act, or ADA. The ADA makes it unlawful to discriminate in all aspects of employment, including hiring, promotion, and termination. Employers must give reasonable accommodations to disabled employees unless it is too difficult for them to do so. Employers refer to this as undue hardship. What is disability discrimination? In our experience at the Employment Law Center of Maryland, the ADA discrimination generally takes one of these three forms. One, taking an adverse action, e.g., firing, promoting, or demoting because of the individual's disability. Number two, failing to grant a reasonable accommodation. Or number three, enacting policies or practices that have a disparate impact on the individuals with disabilities. The ADA protects individuals with disabilities, and it defines disability in three main categories. Number one, an individual with a physical or mental impairment that substantially limits one or more major life activities. Number two, an individual with a record such as an impairment. Or number three, an individual who is regarded as having such impairment. An individual is considered to have a disability under the ADA if any of these three categories apply. Importantly, if an impairment is temporary, it usually does not qualify as a disability under the ADA. To qualify for ADA protections, an individual with a disability must be qualified for the job in question. This means that the individual with the disability must be able to perform essential functions of the job with or without accommodation. The burden is on the individual to show that they can perform the essential functions of the job. Oh, thanks, Mildred. Oh, you're welcome, Mildred. It's also possible to bring a hostile work environment claim related to the ADA in situations when an individual with a disability is being harassed at work because of their disability. The ADA hostile work environment claim has slightly different requirements as those mentioned above. So you should contact a Maryland or any of your state disability discrimination lawyer if you're being harassed at work because of your disability. And the reason I say other states because people live in different states, and of course different countries, so it might differ for who you contact for that. Reasonable accommodations. In addition to the ADA discrimination claims when an employer takes adverse action against an individual with disability, a Maryland or any of your state or country's employer can also violate the ADA. Well, this is for the U.S., so I guess it would just be the states. This particular case is where I got this information is based on the state of Maryland. I live in the state of Maryland, but of course it can apply to all of the different states. So, like I was saying, okay, so failure to provide a reasonable accommodation to an employee or job applicant. Under the ADA, a reasonable accommodation includes the following. Number one, making existing facilities used by employees readily available to and usable by individuals with disability. Job reconstructing part-time and moderated work schedules, reassignment to vacant position, acquisition or moder, moder, mod, modification, of equipment or devices, appropriate adjustment or moderations of examinations, training materials or policies, provisions of qualified readers or interpreters, and other similar accommodations for individuals with disabilities. But as the term itself suggests, a accommodation must be reasonable. This is often the crux of ADA discrimination disputes, as there is no clear-cut line for what accommodations are reasonable and what accommodations are unreasonable. This is why in Maryland, particularly this is where this is based on, your employer has to engage the interactive process, which is a negotiation about the accommodations you will need. Of course, this would be different in different states. I'm not sure if the same things apply for different states, because sometimes it may be different based on the state, whatever the state mandate or whatever it is, but I'm assuming it's probably similar. That's just Mariah's point there. Where's that at? Oh, yes. A general rule, an accommodation is unreasonable if it causes an employer undue hardship, which often means that it is prohibitively expensive or difficult for an employer to enact. This is where I got this information from. The Employer Law Center of Maryland, we frequently assist in Maryland workers to put reasonable accommodations in place. Each state probably has their own reasonable accommodations in place, so it depends on the state. Well, also me being part of the disability community, I think a lot of the time people do have disability discrimination, but they don't talk about it or we're not aware of it. State disability discrimination laws. Disability discrimination in Maryland is prohibited by Maryland Code State Government 20-606, known as the Title 20, which operates similarly to the ADA in many respects. Title 20 prohibits discrimination based on A, disability unrelated to nature and extent, so as to the reasonability precluding to the performance of employment. Title 20 defines a disability as a physical disability, impairment, malformation, or disfigurement that is caused by bodily harm, birth defect, illness, including epilepsy or a mental impairment and deficiency. Generally, this is the same conditions that are will qualify as a disability under the ADA. For anyone that doesn't know, that's the American Disability Act. That will qualify under Maryland Title 20. I don't know if there's different titles in different states. I do know about Maryland Title 20 here. While the ADA and Title 20 are very similar in how they operate, the Court of Appeals of Maryland recently noted that Maryland regulations require an individualized assessment by employer of the employee's ability to perform the essential function of a job, a process according stronger protections for the employee than federal interactive process regulation. Because of Title 20's stronger protections, it may be advised in some situations to pursue a disability discrimination claim under Maryland's Title 20 rather than the ADA. At the Employment Law Center of Maryland, we review a potential client's disability discrimination claims under the federal, state, and local law to determine what the best path of success will be. Claiming a disability discrimination case. If you sue for disability discrimination in Maryland, you need to administratively exhaust your claim. This means you need to file an administrative complaint for disability discrimination before you can file a lawsuit in state or federal court. Like most employment disability discrimination cases or causes, under federal or state law, you must comply with strict deadlines and filing requirements. A skilled Maryland employment lawyer will help you file the necessary complaints and keep up to relevant deadlines. And of course, that's probably similar in different states, so it doesn't have to just be in Maryland. But I'm pretty sure there are probably certain titles under different states, because we use Title 20 here. I don't know what other states use, so I can't say. Under the American Disability Act, or ADA, you must file an administrative complaint of ADA discrimination with the U.S. Equal Employment Opportunity Commission, or EEOC, within 300 days of the disability discrimination. I didn't know some of this stuff. I did not know that. I knew about disability discrimination. I didn't realize there was so much involved in this, which I guess makes sense. Once the EEOC has investigated your administrative complaint, they will issue you a notice of right to sue. Once you receive that notice, you have 90 days to file an ADA discrimination lawsuit in federal U.S. District Court under the District of Maryland. Because of the strict deadlines required to pursue an ADA or disability discrimination claim, it is vital that you speak to a Maryland disability lawyer as quickly as possible. Of course, it's not only Maryland, because this just happens to be Maryland, but yeah. So some of these things like I said, some of these things may vary based on where you live, like what state you live in. Today's planned video will be on the topic of Gallaudet University murders, and it will be released today at 6 p.m. Eastern. The next fun unscripted live stream will be on October 20th at 4 p.m. Eastern. And I'm sorry for any loudness. My family is sometimes loud, but this is their house, so I guess it makes sense. Also, I might put up, either I'm putting it up tomorrow or Monday. I'll put up the poll for deciding what topic we can do for when we get to 1700, because we did get to a little over. Well, that also depends on if 1680 sticks. If it sticks, then I'll put it up on tomorrow or Monday for the poll for deciding that topic. The next scripted live stream will be on Saturday, October 25th at noon Eastern. It will be on the topic of forced sterilization of disabled people. Thanks for watching. Love you guys. Bye.